Okay, real estate taxes. Michigan has a somewhat unique system of property taxation, which I have found to be extremely confusing for most property owners. And I don't want to turn this into a lecture on real estate taxes, but I think it's important for people to understand how taxes are determined and assessed in Michigan. Every municipality has a tax assessor, and the assessor determines what is called the state equalized value, or SEV, each year. That is 50% of the fair market value. So every year we look at the assessor looks at what is the true value, true cash value of each property in the township. That value goes up and down with the marketplace. There's no limitations on it. There's no restrictions on it. It simply fluctuates with the market. And unfortunately, in the last few years, we've seen that what goes up can also come down, and most vacation property, although vacation property has held its value better than residential property, most vacation property has in fact declined over the last couple of years. On the other hand, and on your tax bill, there is a second number called your taxable value. And the Michigan voters in 1994 passed a proposal called Proposal A. And Proposal A put a limit on how fast property could appreciate for property tax purposes. That is called the taxable value, and a number was derived in 1995 as the fair market value as of January 1 of 95. And ever since that, in each year, the value cannot go up for property tax purposes more than 5% or the rate of inflation, whichever is less. And every year since 95, the rate of inflation has been less than 5%. So you've seen increases in value for property tax purposes ranging from 1.5%. Actually, there was a negative number in 2010, I think it was, all the way up to about 4.5%. And that number is the number on which your property taxes are based. So you take the millage that has been approved by the voters in that district, and you multiply that times the taxable value, and that number, that resulting number, is the property tax for each parcel of property. That number is called the capped value. The taxable value is called the capped value. And it stays in place until something happens. And that something is a transfer of ownership. And when ownership is transferred, the cap comes off, and the new owners are going to be taxed at the state equalized value, which still in today's world is significantly higher than the taxable value or capped value that the prior owners paid at. What it means is that taxes are going to go up. And this transfer of ownership is a very technical term that will include things that intuitively make no sense. For example, a sale of the property, that's the easiest one. Or a sale of a fractional ownership of property by a tenant in common. That's a transfer of ownership. So if I sell, or if Peter sells his vacation property to me, there has been a transfer of ownership, and I will pay taxes based on a number that is very different from the number that Peter was paying on. You can also get a transfer of ownership from a gift. And a lot of parents, for estate planning purposes, want to make a gift of the property in stages to the next generation. But that gift of property will, in fact, be an uncapping event. And the way a gift is made is to write a deed. And when you write a deed and record it with the Register of Deeds, you are also required to provide the assessor with a document called a property transfer affidavit. And that property transfer affidavit is the key to the assessor that there has been a transfer of ownership. And that is what is used to uncap the taxes the following year. The death of an owner of property, or a death of a tenant in common, or death of a last joint tenant, all of those things are a transfer of ownership. Now, I need to add that we can create the LLC and put property into the LLC without uncapping, even though title has transferred from individual to LLC. We could do that without uncapping so long as the owners of the LLC are the same as the owners of the real estate before the transfer. So mom and dad, for example, can set up an LLC, transfer ownership from their name to the LLC, and then mom and dad are the only owners of the LLC, so that the owner of the LLC is the same as the owner of the real estate before the transfer, and that transaction is not a transfer of ownership, even though it is a transfer of legal title. The other one that causes a great deal of confusion, and I think there's a lot of misunderstanding on, is when property is owned by a trust. Because I can't tell you how many clients have come to me saying, well, there was no transfer of ownership when mom died because title to the property was in the trust, it still is in the trust, and therefore there's been no transfer of ownership. That's not what the law says. The law says if property is owned by a trust, there is a transfer of ownership for uncapping purposes whenever there's a change in the beneficiaries of the trust. And the way that most moms and dads write a trust is they are the beneficiaries during their lifetime and the lifetime of the second to die spouse. But when both spouses are deceased, the beneficiaries are now the kids. And when that happens, even though title to the property is still in the trust, there has been a change of beneficiaries, and that is an uncapping event. Uncapping means that the taxable value is reset at the SEV the following year. And since vacation property has appreciated significantly since '95, it is not at all unusual to see taxes go up by a multiple of 2 or 3 or even 4 times when there is a transfer of ownership for uncapping purposes. So you can see this is a chart that shows the green line is the taxable value and the red line is the SEV, the true cash value. And you can see that the ownership transfers are going to uncap the width of that yellow arrow at whatever year it occurs. You can see that property values declined somewhat starting in 2008. And that, in fact, that year 2010, there was also a decline in the taxable value because there was an inflation rate that was negative, is what it amounted to. We had deflation that year. That determination is made by the Michigan Department of Treasury. They published that number in July. I have not seen it yet this year, but it is published in July and it will apply to increases in the year 2013. But you can see the upshot of this is that property values declined starting in 2007 or 8. So values are going down, but remember what the Proposal A said, and that is that taxable value will increase each year by the rate of inflation or 5%, whichever is less. So in Michigan, we've seen taxable values going up while property values are going down. And only in Michigan can you see that event, which means you're going to pay higher taxes next year even though your property is worth less. Doesn't make a whole lot of sense, and I don't think that people anticipated this market scenario when Proposal A was written, but that's in fact what's happened. And so if you have looked at your notice of assessment that comes out by March 1 of every year and shows your values for taxes for that calendar year, you will see that the property is worth less and yet your taxes have gone up. Sadly, I know of no way of avoiding uncapping once per generation that does not present other significant problems. And as a result, there is a general rule: if there's a large gap between your taxable value and your state equalized value, you want to delay uncapping as long as possible. Now, that slide was written a couple years ago, and in March of last year, the Michigan Supreme Court came down with a decision that shocked everybody, all of the practitioners of property tax law. Mr. Klooster was a resident of the city of Charlevoix. and his parents had the foresight to put property in joint name, not only between mom and dad, but also with young Nathan. Nathan being Nathan Klooster. And when mom and dad died, the form of ownership that they used is called joint property with rights, full rights of survivorship. And what they did was to, in fact, create a form of ownership that would automatically transfer a decedent's interest in the property to the other owners when one of the owners died. So to take the example in this case, mom and dad added Nathan to what's called title to the property jointly with rights of survivorship. Mom and dad then lost their ownership. One died and the other just disclaimed. They just gave up their ownership. And the city of Charlevoix said, well, geez, we've got a new generation of ownership. The system's designed to uncap once every generation. And either adding Nathan to the title was a transfer of ownership for uncapping, or when mom and dad no longer had an ownership interest in the property, that must have been an uncapping event. One of them was an uncapping event, and therefore we're entitled to raise the taxes on the property that Nathan has to pay. And Nathan took offense at that conclusion from the city of Charlevoix and started a lawsuit. And that lawsuit went on for several years and finally found its way to the Supreme Court of the state of Michigan, who on March 10 issued a proclamation that is still a surprise to everybody. And that is neither the creation of joint ownership with rights of survivorship nor the subsequent death of the original owner resulted in uncapping. Okay? So if somebody comes to me and says, I'm really worried about taxes at the next generation, is there any way that we can avoid that increase when mom and I are deceased? And the answer is, as of today, with today's tax law, there is an answer. Now, the slide before said there's no way to avoid this without a lot of legal problems. And I will tell you there are a lot of legal problems with this form of ownership. But if the concern is that there's no way to keep the property in the family with the increase in taxes that we're looking at, this is one way that you can avoid that increase in property taxes.